Welcome to today's program titled Guidance on State and Local Paid Family Leave Laws, Part 4, spotlighting federal, Connecticut, Washington, D.C., Oregon, and New Hampshire paid family leave developments. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to go ahead and turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Thank you so much, Kate. Hi, everyone. Good morning, good afternoon. Thank you so much for joining us today for the fourth segment of our Paid Family Leave webinar series. We have a ton of great content to share with you, a lot of updates at the federal level, state levels, and I'm joined by some of the core members of our firm's paid leave team spread across 5 of our offices. So you can see sort of the depth and breadth of our colleagues here. Christy Costantino, Christina Duslak, Stan Hill, and Meg Toth will all be covering different aspects of today's presentation for you. So I hope you're excited. I know we are. As you'll see on our next slide, there is a very sort of jam-packed agenda that we're going to be walking you through. I'm going to start with a very brief nationwide paid family leave overview, just to give everyone a brief orientation to what the landscape looks like today. We're then going to turn it over to Stan to talk about the updates at the federal level for proposed paid family leave legislation, an update on our webinar from segment 3 of this series back in June. We then will turn to the state paid family medical leave updates, and you can see there are 7 jurisdictions that have had developments in the last 6 months or so since we did the first 2 parts of our webinar series. And then finally, we'll round out the presentation today with a very high-level overview of some practical considerations for implementing a paid family leave policy and plan, including coordination and benefits topics. So with that, as you'll see on the next slide, we're going to get going and talk about the nationwide paid family leave overview. The next slide gives you a high-level look at the landscape today. 12 total laws, 10 states plus Washington, D.C., and 1 municipality in San Francisco. The newest location that is added to this list is New Hampshire, which Christina will be spending a few minutes on later in the presentation, gives you an overview of that mandate, or excuse me, of that law, which is different than a lot of the other locations and their paid family leave laws that are listed here. Because New Hampshire does not provide for a paid family leave mandate, but rather a voluntary program that employers can opt into. So a lot of distinction there. The newest law that will be going into effect in the coming weeks and months is Connecticut. Benefits become available for workers starting in January 2022. You'll hear a lot more about Connecticut in a few minutes. As you look at this list, the first 7 or so laws are currently in effect at that state level. So California, New Jersey, Rhode Island, New York, Washington State, Washington, D.C., and Massachusetts are all currently providing benefits to their workers. Some of those laws are only paid family leave laws, which means they don't also cover employee absences for their own serious health condition. They will cover bonding with a new child, care of a family member with a serious health condition, among other absences, but not the employee's own needs. Those states are California, New Jersey, Rhode Island, New York. In those locations, there are statutory disability benefit programs offered at the state level to make up for that gap. The other locations that are in effect, Washington State, Washington, D.C., Massachusetts, and then Connecticut, and going forward, Oregon and Colorado as well, which also do not yet offer benefits to their workers. Those are all paid family medical leave programs where they cover bonding, family member serious health, as well as the employee's own serious health. So that's the landscape as you can see it today. Without further ado, I'm going to turn it over to Stan now to give us some important updates at the federal level, especially pertaining to the Build Back Better Act and its paid family medical leave components. Stan, the floor is yours.
Thanks, Josh. We can go to the next slide. So to set the stage for the political agenda, as you may recall, President Biden set forth an American Families Plan in a speech and a statement he gave to Congress back in April. And paid family leave was part of that agenda. President Biden had envisioned a program that is slightly different than what we're going to be talking about today, although it carries through many of the same core themes, including leave for bereavement, 12 weeks paid family leave per year, and other benefits we'll be discussing. So we can move to the next slide. The current proposal that's being tossed around is in the Building Back Better Act, which you've probably seen a lot in the news being covered as far as the funding levels and exactly which programs and to what extent those programs will survive in any legislation that might be passed by both chambers of Congress. The Building Back Better Act has many different things in it, including paid family leave, and it seeks to amend the Social Security Act by providing a universal paid family medical leave. And by universal, we mean it's not just limited to employees of large employers, and it's not just limited to employees of small employers either. It includes the self-employed and anyone who's really earned income in the past 2 years. The House Ways and Means Committee has looked at it, and now the negotiations in both the House and the Senate are ongoing. Notably, the amount of leave might be reduced as one of the bargaining chips, so that remains to be seen. But we'll be taking a look today at what was initially considered by the House Ways and Means Committee and what is still surviving at this moment in time. Next slide, please. One thing to note procedurally, in order to have a chance of passing, the Building Back Better Act will need to be going through the reconciliation process and not the traditional legislative process where in the Senate you would need 60 votes. Instead, for reconciliation, you need a simple majority, and one of the many conditions to that is that there not be an employer mandate and that it truly be a spending and entitlements bill, and as we'll see, that's exactly what it is. And further, it's noted that, now that we've been through COVID-19 and when we had the FFCRA last year and tax credits this year, the political climate really has never been more conducive than now to passing paid family leave on the federal level. We can go to the next slide. So one thing that's interesting is that the legislation as currently envisioned is funded and administered through the Treasury Department, not the Department of Labor, as one might expect, as the current, FMLA unpaid leave regime is enforced by the Department of Labor. But here we're talking about the Treasury Department, and what we're really talking about is payments to employees who say they are taking leave for a qualifying reason. Employers offering comparable paid family and medical leave can receive a subsidy. We'll talk a little bit more about what that subsidy could look like down the road, but it's likely not going to be a dollar for dollar reimbursement for every dollar an employer might spend. And this is a little bit different than the prior iterations of legislation that had different reimbursement concepts, but I think this is one of those areas that's very much subject to negotiation because employer reimbursement could ultimately have a significant impact on the overall cost and the political palatability of passing something. Notably also, existing state leave laws are not going to be, state paid family leave laws will not be displaced by the federal legislation as currently proposed. In fact, the subsidies will only ensure their survival going forward. We move to the next slide. So who might be able to take leave under the current concept that's being tossed around? Really, anyone who works, and that includes the self-employed, part-time workers, and gig economy workers. The qualifying entitlements really just require you to file an application and to say that you have or you anticipate having a need for 4 or more qualifying caregiving hours in a 90-day period or in 180 days after the application is filed. So it's a very low bar to apply and get in the system, essentially, to be able to claim the paid leave entitlement. And unlike the unpaid FMLA regime that we're all used to, there's no requirement that an employee be working for 12 months or have worked 1,250 hours in the past year for an employer. We can go to the next slide. The qualifying reasons for taking leave track the current FMLA, but have several enhancements to broaden the scope of what constitutes a qualifying reason. So one of the notable proposals is to expand the qualifying family members for which an employee or worker might take paid family leave, to include siblings, grandparents, grandchildren, spouses of family members, and equivalent family member relationships. So that's a much broader scope than the current FMLA. And it also includes 3 days of bereavement leave for a spouse, parent, or child's passing. You can go to the next slide. This is perhaps one of the most interesting parts of the proposal that's currently being considered, and that is that the increment of paid leave, a minimum, is 4 hours per week. And so that includes the concept of taking intermittent leave even on a daily basis, so long as it adds up to 4 hours per week. If that threshold is met, then the employee can get paid for it out of their 12-week-a-year entitlement. And this is interesting because compared to the prior proposed legislation, the prior proposed legislation talked about full caregiving days or half days that are back-to-back. And so by decreasing the minimum increment of leave, we can expect that employees are going to be incentivized not only to use leave that they have a legitimate need for, but also to use leave that they don't have a legitimate need for in order to reach that 4-hour-a-week minimum threshold to get paid. So that's something that we're hoping, that either someone in Congress will recognize, or we'll have to be, working on lobbying the Department of Treasury with their regulations to recognize this is a potential for leave and abuse. And we'll talk a little bit more about that later. Next slide, please. So the paid family leave entitlements, the amount of money that the employee can receive, is on a sliding scale, kind of like your income taxes are on a sliding scale with different percentages for different dollar amounts. And there is wage indexing as well. So the current proposal would increase the dollar amount of the leave entitlement year over year. Interestingly, I did some of the math on this, and so for an employee, say, making $50,000 a year, if they took 12 weeks of continuous leave, they'd expect to get effectively 71% of their salary during that continuous leave period time. If that same period of leave is taken incrementally over the entire year, the employee is only looking at a week-over-week 6.5% pay cut. So it creates another incentive for an employee to take it incrementally, so that their pay week over week isn't impacted nearly as much. So we may see more employees absent from work with this financial incentive or financial protection for taking time off. Next slide, please. One of the interesting features of the law is that if the employee receives paid time off, vacation, or sick leave from their employer, the federal benefits don't apply to that time period. At the same time, the employers can't require their employees to burn off their paid leave concurrently with the entitlements that the employer is providing to the employee as a matter of policy. So this is unlike the FMLA, where as an employer you might require your employees to take their paid leave, their paid time off concurrently with their unpaid FMLA leave. The law does, though, envision that employees could elect to top off their federal paid leave with some amount of PTO or vacation to essentially give them 100% of their pay in that time period, and the details of that have yet to be hammered out. There is, however, a 1-week waiting period similar to what you see on a short-term disability plan. Next slide, please. The law is somewhat toothless in that it doesn't have requirements rigorously around notice. At least at this point, we could see some regulations that might breathe some life into that, but employees would only need to provide 7 days advance notice of the need for leave, and there doesn't appear to be any consequences for the failure to do so. Employees, to get their benefits, simply fill out a claim report, send it into the Treasury Department, and supposedly they're to get paid within 15 days. It remains to be seen whether the government can move that swiftly, but nevertheless, the employee can simply provide a medical certification at the outset with the application, and then every month simply provide a statement to say how much leave they used in that month without providing a subsequent certification month over month. So the employee would have a very easy time of claiming the days of paid leave with the government and getting paid. There are penalties for lying to the government, submitting false statements, but that would then just be between the government and the employee, not the employer in the ordinary course of things. Next slide. Now, the employer can be involved in this. If they offer equivalent paid family leave as a matter of an employment policy, they can seek reimbursement or a subsidy from the Treasury Department. There are several strings, though, that are attached to this, including that the employer's program must offer paid family leave for all of the reasons that the federal law provides, and at the same rates or greater rates, that employees are not required to concurrently take down their paid leave, their paid time off, vacation, or sick time that the employer otherwise provides. And also it prohibits that the employer has to guarantee no discrimination or retaliation, and importantly, the employer has to guarantee reinstatement. So this is, though it's not an employer requirement as a matter of law, if the employer seeks the subsidy, the employer is effectively being required to provide guarantees around no discrimination or retaliation and reinstatement of the job. We can go to the next slide. The subsidy is currently proposed depends upon whether the employer's plan is insured or whether it's employer funded. And the details remain to be ironed out on this, but it's very likely that one may be a better fit for an employer than the other, depending upon the number of employees, the expected usage rate, and what kind of deals are offered on the private marketplace for insured plans. We can go to the next slide. One interesting feature of the legislation currently proposed is that there are separate grants that are available to small businesses with fewer than 50 employees to cover the replacement costs of a worker. So this is separate from the actual paid leave entitlement, but rather the cost that the employer will bear in replacing the worker while the worker is on leave. So it's something that we really haven't seen before, and something that might actually quite be useful to small businesses coming into compliance and affording their employees leave. Next slide, please. Importantly, just sort of as the first of two recap slides, there's no employer mandate here. The employer isn't required to do anything. Employees are entitled to apply for and receive benefits. That's the primary thrust of the law. There is no private right of action then. Employees still can bring claims under the existing laws. So FMLA, ADA, and state law claims are all still available. So if the employee is taking paid family leave for a medical reason that qualifies under the existing unpaid FMLA regime, or qualifies for leave as an ADA disability accommodation, the employee is still protected under the law and still would be subject to not being discriminated or retaliated against, and may have a right to reinstatement. Importantly, state laws are not preempted by this proposal, nor are any of the federal laws sunset by way of this proposal. This is purely a government spending and entitlement program. Next slide, please. This slide is just a bit of thinking around, okay, say someone who traditionally takes unpaid FMLA is now getting paid for it. And if you're an employer who has issues of employees abusing and misusing unpaid FMLA, I think it's important to start thinking about what that looks like if the leave is suddenly paid. So whether that's some sort of continuous leave where an employee is going to, say, Florida to see a relative recovering from surgery and is staying down there for weeks on end, supposedly caring for the relative but might be sitting on the beach, and now might be getting paid that entire time as well. Intermittent leave also, inappropriate uses of that, including moonlighting or taking extended time off during the summer, or taking time off on days that are popular to be taken off, like Halloween or the day after the Super Bowl. So these issues of FMLA fraud, leave, and abuse, and the attendance issues that are associated with that, I think will only be increased in a paid regime where the employees are perhaps incentivized by way of the federal entitlement. So these are just some things to think about going forward, and it remains to be seen what kind of federal regulation might be come along with the new legislation to give employers some opportunities to push back in these areas. Next slide, please. And so as a final takeaway, we're just monitoring this closely, and if you have feedback, provide it to your industry associations, and I think we just all need to stay informed on this, and then ultimately, if there is a subsidy opportunity for employers available, there may be some quick timelines in deciding whether or not to apply for the subsidy. The law is currently proposed will go into effect in July of 2023, and employers would need to apply for the subsidies 3 months in advance of that. So if this is if something were to be enacted here in the next few months, the employers would have about a year to figure out what to do. So with that, Josh, I will yield the balance of my time, or apologize for the overages, and would welcome any questions later.
Great, thank you, Stan. Thanks so much. As everyone can tell, so many moving pieces, and we're so lucky to have Stan helping keep us honest and keep track of all the different moving pieces in Congress right now with these potential mandates coming down the pipe. We're now going to turn to our state paid family medical leave updates. Next slide, please. Great, and we're going to start with Washington, D.C. Chrissy, it's all yours.
Great, thanks, Josh. Next slide. Oh, thank you. So the Washington, D.C. Paid Family Leave Program has been paying out benefits since July 1st, 2020. And since that time, the available benefits have been 8 weeks of paid parental leave, 6 weeks of paid family leave, and 2 weeks of paid medical leave per year. And this slide is just some of the basics of the program as it was originally implemented and continues to play out for reference for those who may not be familiar. The good news about the recent amendments to the D.C. Paid Family Leave Law are that it does not create new buckets or categories of employer obligations. Why it is important is what's available to employees will change, and that could impact, obviously, policy considerations, coordination of benefits, and ongoing notice requirements. Next slide. So as you can see here, this is from the 2020 fiscal year Q3 report of total claims since the inception of the program. This number is just, for reference, as sort of what led to the amendments. These are much smaller numbers than anticipated. This is less than 1,000 claims per month, and therefore the universal paid leave funds that employers are paying into had a much higher balance. That led to some reevaluation of the program during the budget process for fiscal year 2022, which is where we get the amendments. Next slide. So the amendments took effect October 1, 2021. Because of DC's legislative process, they are currently implemented pursuant to emergency legislation, and they are embedded in the Emergency Budget Support Act. If you haven't seen a standalone law on it, that's why. There is identical permanent legislation also pending that's currently under congressional review. The temporary legislation is set to expire in November, and the permanent legislation is set to take effect in January. So we do expect some additional emergency legislation to bridge that gap. Although the benefits already been implemented, the law states that rules should be issued within 30 days. So we'll be looking for those probably around November 1st to address the new elements of the law. And then also new notice templates will be issued sometime in the fall with the expectation that employers will start posting these new versions by February 2022. Next slide. This is just a reminder on the posting and notice requirements under the law, because this is one of the continuing obligations of employers, and it will come into play, which I'll talk about in a few minutes, when employees go to apply for retroactive benefits. One more point on this. Going forward, if the law expands benefits or changes contribution rates, then the current legislation provides that a new notice must be provided 60 days in advance. So as we'll talk about, the new legislation really provides a sliding scale of what benefits will be available going forward. So you'll really have to keep your eye on updated notice and postings in order to comply with these obligations. Next slide. So here's really the meat of the amendments. As I mentioned before, the current availability is listed here in the left-hand column, the pre-amendment availability. Effective October 1st, medical leave has been expanded from 2 weeks to 6 weeks, and there is a creation of a category for prenatal leave. Family and parental benefits will remain the same. Now, the way that the new legislation sets up leave going forward is that there is an annual reevaluation of the level of funding available for benefits, and based on that, availability may be increased or decreased. So you have here on the right what would be the maximum amount of benefits under the law before they would consider a reduction in the employer tax. no matter what the sliding scale of benefits ends up being based on the funding, it will never go below the minimum leave availability noted in the left-hand column. And that reevaluation would be done in the first quarter of each year and then be effective in July of each following year. Next slide. Okay, so as I mentioned here, the law is really aimed at, or the amendments are really aimed at expanding benefits and really getting more of this money into employees' pockets. So the prenatal leave is a new category of leave that will be for 2 weeks. Here we have the types of treatments, appointments, et cetera, that would fall under this bucket. Additionally, the law expressly covers miscarriage and stillbirth as medical leave events. There has been a temporary elimination of the waiting period, as well as a change to the calculation of benefits. Both of those are set to expire on July 25th, 2022, based on when the public health emergency in DC ends. Now, if that changes, these also may be extended, but that's the current time frame. So until then, any claims filed now until then would have no waiting period. Normally, there's a 7-day waiting period, and a longer look back to ensure that employees have the maximum benefits available. Next slide. The expansion of the maximum leave also is impacted by the category of prenatal leave. So now an individual who applies for both prenatal and parental leave can take up to 10 weeks. And obviously with the sliding scale, that may go from anywhere from 8 to 14 weeks, depending on what's available in each fiscal year. There's also the increased opportunity for retroactive benefit applications. And this is where it could be important on employer part, because in this third bullet here, the lack of knowledge due to employer failure to provide required notices. If your employee applies outside of the 30-day notice period, or limitations period, they can say, my employer didn't give me notice, and DOES will have to come back to the employer and certify noncompliance before they can move forward with giving the benefits. So that's a point where they may be coming and asking for proof of notice. And the last piece is the elimination of PFL benefit offsets by short-term disability insurers. This does not apply to self-insured employers or for employers who use insurance companies as third-party administrators. So it's just an application to the insurers themselves. Next slide. In addition, they made one change to DC Fmla, which has expanded employee eligibility. The takeaway here is really now that instead of 12 consecutive months to meet the minimum service requirements, you can look at non-consecutive months to meet that 12-month mark and the 1,000 hours for of service during that time period in order to qualify for a job-protected leave. So stay tuned for the rules and the new notice in the DC Paid Family Leave Amendment update. And for now, we'll turn it over to Connecticut.
Thanks, Chrissy. Next slide, please. Okay. So as Josh mentioned in the beginning of the program, Connecticut's Paid Family Medical Leave Law will be going into effect January 1st, 2022. On that effective date, there will also be changes to the state's FMLA law, which I'll refer to as the CFMLA. So the key thing to keep in mind is that the Connecticut PFML law only provides paid leave benefits. It does not provide job protection. That job protection will come from the state's FMLA law, the CFMLA, the federal FMLA, and actually the state's domestic violence law related to safe time leave. So the way that the Connecticut PFML and the CFMLA are designed is to run concurrently when used for reasons covered by both laws and where the employee has time available under both laws. There will be some situations, though, where an employee may be eligible under one law to receive benefits and not in the other law. And so that's where it's going to be really important to have a good policy in place so that employees can understand how these, what are their rights in terms of paid leave and actual leave entitlement. We expect the Connecticut Paid Leave Authority, the agency that administers this law, to release additional regulations and administrative guidance any day now. Right now, there are FAQs on the state's website that are very helpful and I think are previewing a lot of issues. So definitely something to look for, though. There also have been regulations related to private plan exemptions that are available now. And there's also some new guidance that we will discuss about the interaction between the Connecticut, the CFMLA, the Connecticut state FMLA law, and the paid family medical leave law, especially for employees that start on unpaid Connecticut family medical leave in 2021 and then carry over into 2022. Next slide, please. So we're going to do a quick overview of some of the key things around the law right now, and just some additional background. So the key thing to know is, as of January 1st, 2022, the PFML and then the Connecticut FMLA will cover employers with one or more employee with some narrow exceptions. So this is going to cover most employers. So this is definitely something to pay attention to, especially as we have more and more folks that are working remotely. The eligibility standards are slightly different between the PFML and the CFMLA, and which makes sense in terms of one's providing pay, and so there's a financial eligibility test and certain requirements there. But the CFMLA requires that an employee be employed for at least 3 months. So for new employees, they're, even though they might technically be eligible for pay under the PFML law, they won't have the leave entitlement. So that's something to note. Also, there are very broad reasons for use. So in addition to what's available under the CFMLA and the federal FMLA, such as caring for a family member with a serious health condition, an employee's own serious health condition, military caregiver leave, and military exigency leave, there's also leave related to organ or bone marrow donor, and then also safe time. And so the way that safe time will work is that under the PFML law, that provides pay, and then the leave entitlement will come from the state's domestic violence leave law. And then also notable are the covered family members, which is broader than the FMLA, and expands the current definition of the CFMLA, the current definition of family members under the CFMLA. So some new additions will be siblings, a grandchild, a grandparent, and notably this catch-all that we're seeing with a lot of laws right now, an individual related to the employee by blood or whose close association to the employee is the equivalent of those family relationships. Next slide. So the other high-level thing to consider is that this is an employee-funded program. So employees are, basically there's a deduction that's been going on since January 1st, 2021, where 0.5% of wages up to subject to the Social Security tax are being taxed through a payroll deduction, and then employers are not required to contribute to this program. They are only required to deduct and withhold the contribution amount from employees, assuming that they have not opted in or applied for a private plan exemption. The other thing to consider is the maximum benefit amount that is actually tied to the state's minimum wage. So next year, when the program starts, the benefit will be capped at $780 per week, but we will see that increase to $840 in the middle of the year, and then in 2023, that will be approximately $900 per week. And again, that's tied to a bill that increased the minimum wage over a few year period. Then the other thing to consider is that an employee may supplement PFML with other forms of paid time off up to 100% of the employee's pay. And covered employees cannot receive PFML compensation at the same time they're receiving unemployment compensation, workers' comp, or any other state or federal benefit that provides wage replacement. And then finally, an employer can require an employee, or they can make it an option to the employee to substitute accrued paid leave for any part of the 12-week period, as long as employees are allowed to retain at least 2 weeks of leave in their bank. Next slide, please. So one of the other things that I previewed is that we're seeing more workers working remotely. And so can we do the next slide, please? All right, great. And then, so for that, there could be employees that are working in Connecticut and another state. And so I know this is a challenge that we've been seeing with a number of employers. So the test that has been put out there is that if an employee is subject to unemployment insurance obligations, then the employee is going to be covered by the Connecticut PFML. And then if the employee is currently not subject to the unemployment insurance obligations, then you're going to actually look at the same text that's used to determine whether or not an employee is eligible, to determine whether or not the employee works in Connecticut. So basically, this is the state saying, are you really sure that they shouldn't be covered by unemployment insurance obligations? And it goes through this kind of four-part test in order of priority. It's a fact-specific test, and we encourage you to talk with legal counsel if you have questions about this, because it is pretty complicated. Next slide. So the amount of leave, so as of January 1st, 2022, employees will be eligible to receive pay for 12 weeks of paid family and medical leave, and then there may be an additional 2 weeks of pay related to a serious health condition related to incapacitation that occurs during pregnancy. Now, what the PFMLA also did is amend the current CFMLA. So currently, employees are receiving 6 weeks of unpaid leave in a 24-month period. As of January 1st, 2022, that will change and it will align with the PFML law. Next slide, please. So that will create questions for employees who are currently approved under the current CFMLA law and are on unpaid leave. So the guidance that we just received from the state states that for the duration of the leave, it's going to be capped at 12 weeks in the applicable 12-month period as of January 1st, 2022. And you can see here, it's even if the employee was approved for and commenced a 16-week leave under the CFML law. Generally, in 2022, the employer can look back over the applicable 12-month period to see if the employee has used any leave to determine if they have time available. And how you do this will depend on your applicable 12-month period. And that refers to the method for calculating the CFMLA benefit year. And I'm sure a lot of folks tie this actually to their federal FMLA benefit year as well. So how that looks will depend on what, how you set the applicable 12-month period, and there's additional guidance and examples that can show you how to navigate that. Next slide. And finally, notice is not going to be required until July 1st, 2022. There's no posting requirement. And, the obligations right now are remitting contributions. The state has provided in this first year only pretty much a grace period every month. So normally you would be providing contributions every quarter, like March, and end of March, end of June, end of September, end of December. They push that back each quarter. So the third quarter is due October 30th. And the next payment is currently scheduled for December 31. They haven't pushed that back yet. So look for that. And then finally, as I noted at the beginning of this, because this law involves both, the PFML law, the CFMLA, and just coordinating with also federal law, we highly recommend having a policy so that this leave not only interacts with state and federal law, but then also your existing policies. Okay, next slide. Oh, sorry, missed the next slide. All right, and then we're going to keep going into Massachusetts now. So Massachusetts, just get this to the next slide here, into Massachusetts. So one of the big changes for Massachusetts, and I'm going to do a pretty brief overview of Massachusetts overall. You can refer to our part 1 of our webinar series, which went more in depth to some of the updates to the law and just how employers are navigating as this program starts this year. But just as a reminder, Massachusetts provides both job protection and leave benefits. And as of July 1st, 2021, leave to care for a family member with a serious health condition went into effect. Next slide. And so the state has provided guidance that any leave taken to care for a family member with a serious health condition under another program will not reduce the 12-week leave allotment under the PFML. However, family leave has other reasons for use. That 12-week allotment has other reasons for use. So if a worker took leave to bond with a child or to care for a family member who is an active service member between January 1st and June 30th, and that leave qualified under the Massachusetts PFML law, that leave will reduce the employee's leave allotment. So for example, if they took 8 weeks to bond with a child in May of 2021, or ending in May 2021, they would only have 4 weeks of leave to care for a family member with a serious health condition as of July 1. Next slide. So for employers on the public plan, there also has been some additional guidance related to substituting accrued paid leave. So as a reminder, employees cannot receive, cannot take accrued paid leave to top off their state benefits when they're under the public plan, except for that initial 7-day waiting period where they're not receiving benefits from the state. But after that point, the state has said that employees on continuous PFML leave can only use PTO or accrued paid leave in a single continuous block at either the start of their leave or the end of their leave. If they don't, it could end up messing up their benefits and they'd have to reapply through the state. And so this is an administrative issue for the state and something to note when employees are planning their leave. Next slide. The weekly, maximum weekly benefit amount just increased as the regulations state it will do every October. And now it goes from 1,000, it now will be at $1,084.31 as of January 1, 2022. That's up from $850 per week. And then next slide, as of January 1, 2022, we're going to see that the contribution rates that employers and employees owed has actually declined, or has decreased. Next slide. All right, so now we're going to cover New Hampshire. So this is an interesting law, and as Josh noted at the beginning of the program, there's a notable difference with this law is that it's voluntary. So the goal is to allow employers to buy advantageously priced family and medical leave insurance so they can provide wage replacement benefits to employees. So what this law does is, there's a component related to state employees that we're not going to discuss, but for private employers, it will establish a purchasing pool of family and medical leave insurance so that employers can offer, who choose to, can offer coverage to their employees. It will also provide an individual opt-in coverage option for employees who employers choose not to offer coverage. So the way that it will work is coverage will be provided by the winner of a bidding pool between accident and life insurance carriers. And New Hampshire essentially is going to issue a request for proposals by March 31st, 2022. And then the actual leave for employers who opt in and employees who opt in will be on January 1st, 2023. And at that point, employees will be eligible for 6 weeks per year for a qualifying reason at 60% of their average weekly wage. And where the incentive is for employers to opt into this program is there will be a tax credit to cover about 50% of the premium in the taxable period. So that's something to note about this law. We expect that the Department of Administrative Services that will be administering the law is going to be establishing rules for a base period, minimum participation requirements, and open enrollment period and the parameters, and procedures for contributory plans, including like payroll deductions and payment of contributions. The other notable thing is that opting into this program will mean that employers are going to be subject to job protection and anti-retaliation provisions that are pretty much in line with the FMLA. Next slide. So private employers can choose to offer this coverage if they have 50+ employees. Now, the law does not specify whether an employer has to have 50 employees in the state or anywhere in order to participate, so that's something we'll be looking for guidance on. An employer can choose to provide coverage at no cost to the employee on a contribution basis or on a partial contribution basis. And then employers who do, who do have 50 or more employees who choose to sponsor coverage are going to contract directly with the winning bidder for this. Now, as I noted in the beginning of this presentation, individuals may purchase coverage through a purchasing pool. So the way that that will work is that there will be a 7-month waiting period, a 1-week elimination period, and a 60-day open enrollment period. Premiums for individual pool coverage are not going to exceed $5 per week. Next slide. So the reasons for use for this law are pretty similar to the FMLA, with the exception of leave for an employee's own serious health condition. So to be eligible for granted state medical leave, the employee has to opt into the program via the purchasing pool. They have to have a non-work-related illness or injury. In other words, they can't be receiving workers' comp at the same time. And they have to work for an employer who does not offer a short-term disability insurance program. Next slide. And then covered employees are going to be a child with the same definition as the FMLA, a parent and a grandparent, and that will cover biological, adoptive, foster, step. And then with the parents, they'll also be legal guardian of a child or a child's spouse or domestic partner, and then spouse or domestic partner. And then for military caregiver leave, there's also that next of kin definition as well. All right, next slide. So anyway, we're going to be seeing some more updates on this law, so definitely stay tuned there. And then we have some brief updates on next slide. So Rhode Island has actually increased the amount of leave available under its temporary caregiver insurance program, which is essentially family leave. So currently the law provides 4 weeks of pay and leave for employees to care for a family member and for bonding and whatnot. That will increase to 5 weeks on January 1, 2022, and 6 weeks as of January 1, 2023. Next slide. And then finally, we're going to turn to Washington family leave updates, or finally for me. Now, there's going to be, you can go to the next slide. We're actually going to have some more updates, or this is just a very brief update, but you can get some more information about this law in part 1 of our webinar series where we covered this more in depth. But the key thing to know right now is that the definition of family member actually expanded under some new amendments. And so previously it only covered a child, a grandchild, a parent, a sibling, or a spouse. And now we've seen one of these kind of catch-all definitions, as I mentioned, is a trend right now with a lot of these laws. And so now it's any individual who resides with in the employee's home, or where there's a relationship that creates an expectation that the employee cares for a person. So it's kind of either or there as, condition 1, and then condition 2 is that the individual has to depend on the employee for care. So overall, this will not include any individual who simply just resides in the person's home, but then it doesn't have the expectation of caring for the individual. And that's all that I have right now. I'm going to turn this over to Meg for Oregon. Thanks, everyone.
Thanks so much, Christina. I'm going to jump right into Oregon just so we stay on time here. So the big thing to understand about in terms of updates for Oregon is really just one thing related to the relevant dates and the timing for the rollout. It was enacted back in 2019, but due to some delays with COVID, they've amended the law and pushed back some of the important operative dates. They were going to be issuing rules around this September of 2021, but that's going to be pushed back to September of 2022. Payroll contributions were actually supposed to begin January 1st of 2022, and now that's going to be January 1st of 2023. The written notice requirements to employees is going to align with the contribution date of January 1st, 2023, and then the benefits won't actually begin for employees until September 3rd of 2023. So that's delayed by about 6 months. So that's really the big update for Oregon. I'm just going to, on the next slide or next couple of slides, I'm going to talk through just as a reminder of some of the most important aspects of the paid family leave law. The amount of leave is 12 weeks per benefit year for family leave, medical leave, or safe leave. It's important to understand that this paid family leave law does not sort of take over the unpaid Oregon Family Leave Act and employees are going to be allowed to use up to a combination of 16 weeks total of paid family leave and then the unpaid Oregon Family Leave Act unpaid time. And then there's 2 weeks available for limitations related to pregnancy, childbirth, or other conditions such as lactation. And it's just important to understand the total time will never exceed 18 weeks. Okay, and then on the next slide, in terms of the amount of pay, I won't get into great detail here. It really is going to depend on what, at the time, the state average weekly wage is and whether or not the employee earns 65% or less, or if they earn more than that. As you can see on the slide, there's going to be sort of a detailed calculation in terms of how much they make based on that average weekly wage. So look out for more information on that as we get closer to the rollout date. And then looking at the reasons for leave, as I mentioned previously, they're pretty similar to the other states we've talked about. Medical leave for the employee's own serious health condition, family care leave, which covers bonding with a newborn or newly adopted child, or to care for a family member with a serious health condition. And then there is also a safe leave component, which covers various reasons when the employee is a victim of domestic violence, sexual assault, harassment, or stalking. And then it's important to remember, too, this does not cover bereavement like the Oregon Family Leave Act does, or family military leave reasons. And then finally, a few, on the last slide here, a few other important things to remember. Employer contributions, those start January 1st of 2023. Employers are going to be required to deduct 60% from the employee and contribute 40%. There is a notice requirement, which is effective January 1st, 2023. This law does provide job protection if the employee had been employed for 90 days, except there is a small employer exception where there's less than 25 employees. That is going to be, it's not going to be job protected. And then there is the opportunity for private plans, which we will talk about here in a second under the considerations, practical considerations for rolling out policies and plans. So I'm going to turn that over to Josh to kick us off with this section.
Great, thank you, Meg. Hi again, everyone. Such a great amount of information there. You can see in just a few months' time, all the moving pieces at the federal and state level. So definitely stay tuned for more updates from our team as more developments take place between now and the end of the year. With that, as you'll see on the next slide, we're going to spend the last few minutes we have with you going over some practical considerations for implementing a paid family leave program. And one of the big ones, and perhaps the most important of the various topics when you're actually on the ground and implementing and dealing with these laws, is how do state paid family leave laws integrate with and coordinate with different other company programs, state laws like the unpaid FML laws that have been mentioned in a couple of locations, Connecticut, Oregon, for example, as well as the federal FMLA. And when we're talking about federal programs, we're not just, or excuse me, employer programs, we're not just talking about employers' paid parental leave benefits, short-term disability benefits. Those are certainly relevant as well. But companies can also have PTO policies, vacation policies, sick policies, and how you integrate those different plans along with the longer-term STD, paid parental leave, paid maternity leave, caregiver leave policies with state PFL can get quite complicated in practice. So it's those moving pieces in terms of what's getting coordinated with what isn't enough. What gets also complicated in this space are unclear legal standards. A lot of laws will not differentiate between their coordination and benefit standards for paid parental leave and short-term disability versus PTO, sick, vacation. And there are some inherent differences between those two sets of benefits. Most importantly, where you have laws that might exist that do not allow an employer to require the benefits to run together at the same time, to run concurrently. That can really trickle down when you start thinking about short-term disability and paid parental leave benefits and the potential for those leaves to stack and not run together, and the cost and the absenteeism and the practical administrative challenges that can result from that. In addition, how the company's policies are worded, right, in terms of coordination of benefits, saying that the times will be counted together, but in making sure you account for other location-specific carve-outs as needed based on these PFL laws, also becomes significant when you're dealing with the potential to run the times concurrently. And then finally, there's also an element that depending on how your company's short-term disability program is set up, perhaps your company paid parental leave plan is set up, if they are designed as ERISA plans, making any changes to them based on the ramifications of a state paid family medical leave law can directly result in ERISA considerations and needing to make sure you follow the right processes there as well. So that's the landscape that we're up against. It's something that a lot of companies will tend to overlook. They usually will simplify matters and say the benefits will just run together, we'll offset the pay by topping up the pay, based on whatever the state provides and call it a day. And unfortunately, that isn't as clear as this topic needs to be when you are working through different state locations. As I said, the locations language from those laws will really be important, whether they require the employer to offer the worker the option of choosing whether the benefits will run concurrently. That can lead to a lot of absenteeism. Some of the trickiest laws in that space are Washington State, New Jersey, Massachusetts, although each of the jurisdictions has different components that need to be thought through and analyzed. Another big piece of this coordination and benefits topic is understanding what aspects of your company policy are at play and that are less favorable to the worker than the state program. For example, if your company policy might say on paid parental leave that the time needs to be taken in one continuous block right after the bonding event, right? Not within 12 months after the bonding event or not intermittently, maybe on a weekly or daily increment, that company policy would not be consistent with and would be less favorable to the worker than most of these state paid family leave laws. That could impact the company's ability to have the benefits run concurrently and result in the time loss stacking on top of each other, greater absenteeism, and so forth. Understanding concurrent use is also really important for job protection purposes, knowing that some of these laws might not provide full job protection. They might only provide wage replacement benefits. So the worker's right to reinstatement after leave will hinge on whether the FMLA or state unpaid FML laws or other company policies are at play as well and are running concurrently. That's a very quick high-level overview. We're going to plan some additional updates and discussion on this topic and dive into some of these very high-level points in a later segment of our webinar. Hope that at least gave you a little bit of an appetite for how clunky this setup can be. And with that, I'm going to turn it to Meg to talk us through written policies and plan considerations. I was going to just go back one slide for us, please.
Oh, great. Thanks so much, Josh. So in the last few minutes here, we're just going to talk about an important distinction between a paid family leave plan and then potentially a paid family leave policy. Paid family leave, as you all have probably gathered from this presentation, is different than many of the paid and unpaid leave laws that we're familiar with because it doesn't just involve developing and rolling out a new policy that meets certain requirements. There is either going to be a state or a private insurance plan that also must be set up to comply with these laws. So in addition to considering how much time to provide, how much pay, the reasons for use, notice requirements like a typical leave policy, there must be an insurance plan or plan-like document either through the state or through a private plan in the background. But in some cases that isn't necessarily sufficient. And so sometimes I think we see a lot of confusion among employers who set up the plan and that's all they do and forget that they may need to have an employer or an employee-facing policy. And in some cases it's legally required, for example, in New York and San Francisco, if you do have other leave policies, that you actually have a policy to, not just a plan setting forth what the various benefits are and different obligations. So I think many employers are used to insurance benefit plans like STD, where there rarely is an accompanying employer provided policy or notice or a poster that goes along with it. But paid family leave, sort of incorporates both the requirement to set up a plan, either through the state or privately, and also has policy considerations in addition to that, specifically in New York and San Francisco. And then, as we sort of mentioned, there are also notice and poster requirements, which I won't get into too much detail, but this was just sort of a reminder that, once you get a plan set up, don't forget that there may be either legal requirements to have a policy or, best practices reasons to be, rolling out a policy to address some of the coordination of benefits that Josh was talking about. And then just a quick note, I know we're up at the end of time here about private plans. Virtually every law allows employers to establish a private or a self-insured plan rather than using, the state plan. sometimes called voluntary plans, except for Washington, D.C. and Rhode Island. But it's important to remember if you're going to be exploring or looking into private plans that there can be additional considerations, an application process. They must be approved by the state in order to start using them. You can't just set up a plan and run forward. There is usually an approval process. In California, or I would say just generally, as long as you have a private plan that is as generous as the state plan, then it probably is going to be, meet the requirements, except for California, which requires at least one benefit or right that is greater than the other state plans. It's also important to be aware that in some states, having a private plan also requires other obligations. For example, in California, New Jersey, and Connecticut, employers have to attest that they got approval from the private plan from a majority of their employees, which, requires a vote of some sort. And I know we're up at the end of time, so I want to read the CLE code before we wrap up for anybody who has to jump. That is SS8377. Again, SS as in Seyfarth Shaw, 8377. And if you have any questions about private plans, feel free to reach out to any of us. I know we kind of got cut short there, but I'll turn it back to Josh to close us out.
Great, thank you, Meg. As you'll see on the next slide, there is a lot of moving pieces within the paid family leave space. And as you'll see, Seyfarth has maintained and continues to maintain a number of valuable resources. On the next slide, you'll see first we have a paid family leave survey, a comprehensive survey that breaks down all state and local paid family leave, paid family medical leave laws. We've included a website there, an email address for you to reach out to that we monitor and maintain. We'll get back to you as quickly as possible if you want any more information. We also have a paid leave mailing list, free to sign up so you can get all of our legal updates, blog posts on paid family leave and other paid leave developments. As we know about them, we'll roll out our alerts. You'll learn about them as well. Thank you so much, everyone, for joining us today for our fourth segment of our paid family leave webinar series. Thank you for those who submitted questions. We've done our best to respond to those in the chat group as well. We look forward to seeing you at the next segment of our webinar series. Hope everyone stays safe and well. Thanks.